that to the state-initiated process is able to dictate the substance?
Well, I think that the two answers you've just heard would lead to utter paralysis for those people who want really to have an Article 5 convention, something that I said I'm at least open to thinking about. That is, how is it ever going to happen? As a practical matter, I do agree that Article 5 should be read to oblige Congress under certain circumstances, which I can't fully define, but there have got to be circumstances. Suppose all 50 states were to petition Congress to convene a convention to consider amendments to restrict or overturn Citizens United. Suppose it was phrased that way. Now, obviously, at that point, it would be political suicide for members of Congress to thumb their nose at these 50 state calls. At that point, if there really were to be a convention, I would agree with my colleague Larry Lessig that under the necessary and proper clause, Congress would at least have authority to enact facilitating legislation. I don't think that that legislation would have the power to prevent the convention from proceeding. I think that it would have to facilitate it. And I agree that the line between facilitation and prevention may be hard, and I don't think the U.S. Supreme Court would get involved in the act. But there's an awful lot of constitutional law that is made outside the Supreme Court. What constitutes an impeachable offense? When has the president unlawfully taken the nation to war? We resolve those questions through political struggle and through dialogue and conversation of the sort we are having here, not necessarily through litigation. But I think if we take the position that Congress is powerless to actually act on these applications by saying, all right, here's how the delegates might be chosen, here's how the money to pay the delegates would be raised. If Congress can't even do that, so that there would be a first meeting at which the convention could then create its own rules of proceeding, then we would basically be at ground zero. And I don't think that that's a reasonable way of interpreting Article 5.
Okay, to my right.
Yeah, my name is Raymond Lauda. I'm the author of the op-ed piece, Two Constitutions, Two Futures, that appeared in the Harvard Crimson on Thursday. A brief statement and a brief question. My statement is that I think it's unconscionable that the real alternative to the problems that we face in this society and the world, that is the Constitution for the new socialist republic of North America, is not being taken up here. This is a vision and a viable plan for a liberatory society that would be tackling and overcoming racism and the oppression of women, that would be developing an economy that speaks to the great interests of humanity and protects the ecosystems of the planet, and that would be contributing to create a world in which human beings could truly flourish.